Hello, hello. Excited utterance here and
Dolly.
have Dali talk with me. And it's a special dual stream today.
Yes.
It is a special dual stream, and the topic today is Doomsday. Doomsday. Yeah, it's a bit of a serious topic. Although we try to make serious topics more
Yeah,
enjoyable by
we try.
just, being ourselves. Why not? Indeed.
Indeed.
Yes. Never covered this topic before because, in our streaming lives, there's never been hey Wesley. It's not even Tuesday, is
No, it's
it?
Wednesday.
It's
Yeah, it's
Thursday
Wednesday.
here.
Yeah.
Yeah, we're a long way behind. Uh, hey, half Irish. Yeah, we've never covered this topic before because I don't think we've been streaming long enough for
No.
to cover the Doomsday couple.
Yeah.
But I was brave enough back in what was it, March or
Mm.
April or something like that, to try and listen to the entire Laurie Vallow
Mm.
Daybell trial at nighttime, whilst also watching the Letitia Stout trial during the daytime,
Nice.
which was
Yeah.
crazy overload. If you, if crazy, if I'm not crazy enough myself in my own real life, then there's those two crazy cows.
Yeah.
So yeah, that was quite enough. Oh, you were traveling back in time, were you,
Mhm.
Wesley? Okay. Hey, little peanut, how's it
Hey, how you
going?
doing?
Good. Alrighty. So what got our attention was the other day. I think it was Jung said said that there is a status conference going on. Well, she actually, Lawn Cream said that there was going to be, well, there was actually something on Lawn Cream saying that, oh, look, the Doomsday Dad trial is on. I'm like, what's going on?
Yeah.
But no, there was nothing like that. But there was a status conference going on. And whilst these things look a little bit boring on the surface, when you actually start watching them, you can see that the wheels of justice have started moving. And if you have faith, then you have and you look and you watch, you can start to see that some interesting things are unfolding. So we're
Yes.
going to have a look at that status conference. But before that, I thought, okay, I'm going to have a little bit of a dig about, and so is Dali, and see what else has been going on in the Doomsday world. Now, another thing about this, and this is interesting for Mr. Dali over here,
Yes.
who lives in AZ. Do
Yep.
you want to talk about this, Mr. Dali?
Yes. So when if the Lori Vallow trial comes to Arizona, it'll be in my county. So I'm hoping to go over there. It won't be till next year, later in the year, but I am hoping to get inside and get a look at everything.
How
Very exciting.
excitement. How excitement. So we could have a MLSN reporter on the ground.
Exactly.
Oh my God, how exciting. So, what we have, oh, hey, Melissa Jane. Hello, how are you? No, first Aussie in chat today. First Aussie in chat. All right. So, what we're going to do is I actually found a little bit of sort of let's do a little preamble to the status conference just before we get into it. Now, lovely Nate from East Idaho News, and you know that East Idaho News covers the um, covered the trial really, really well from a reporting perspective. And I really turned to East Idaho News for the audio when I was crazy enough to try and listen to the whole thing early
Yeah.
in the year. And Nate was fantastic. So the storm is coming distant. What'd you say, half Irish? The husband's trial. Can't remember his name right now. It's Chad Daybell. Chad Daybell. Yeah. So I just wanted to show a little bit of commentary from Nate from East Idaho News, because 5 days ago he gave a little bit of a roundup on what's happening, not only with this this conference that's coming up, but also the lorry situation. So just want to pop this on for a moment, not for too long, and then we'll get into the conference. Okay, so let's do that. Alrighty. Okie dokie. And we'll go. Where are we? La da 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 da. There we go.
Grand
Oh, he's very low.
She was found guilty in May, the Friday before Mother's Day, and then in July,
Hello,
the last day of the
Christine.
month, she was sentenced to life in
Do you have a
prison,
booster?
3 life sentences with no.
Yeah, I
no
do have a booster.
possibility
He is
of
quite
parole.
low, actually. I'm just
Next
going to
day, she was moved down to the
turn him
Idaho
down.
Pocatello Women's Correctional Center, the
Better?
maximum security prison in the state of Idaho,
Yeah.
where she has been ever since. Now, in between all of that time, actually that week she was moved, I believe Arizona said, we intend to get the extradition process moving. We want to get her here to Maricopa County, where she faces, or she's been indicted for the being.
Oops. Sorry, just going to move this there.
Connected to the deaths of Charles Vallow and Brandon Boudreaux, her former nephew-in-law. So she's still here. She has not been moved to Arizona. It's been now over 2 months since she was moved to the Pocatello prison, and she could be there for, we don't know how long. It's now a conversation between the state of Arizona and the state of Idaho. Who's going to house her? Well, she's being housed in Idaho. Well, if they move her to Arizona on those charges, and if she's found guilty there, then who houses her? What if she gets a life sentence in Arizona and one in Idaho? What if does Idaho then take her back? I mean, I'm sure all of these things are being discussed. There might be a possibility that Arizona doesn't even take her until the appeals are done in Idaho. That's just me speculating, one possibility that's been thrown out there. I'm not really sure. I have heard and do believe that she may be moved to Arizona by the end of the year, and that then things could pick up in those proceedings. So in the meantime,
okay, I get what you're saying. So yeah, half Irish. So what the charges in Arizona are for the unaliving of her other husband. So that's Charles Vallow. Yeah. So a lot of testimony was put forth in the first trial about Charles Vallow and about the unaliving of him. And the other thing is that there is another player in this, her brother, Alex Cox, and he is no longer with us either. And he is actually listed as a co-conspirator. So there is, people think about this as it being just Laurie and Chad, but it's not just Laurie and Chad. It's Laurie, Chad, and Alex. And they're 3 co-conspirators. Unfortunately, you can't be getting Chad up for charges because he is unalived. So no longer with us. And yeah, he's the one, apparently, allegedly, who stabby or whatever it was, the Charles Vallow. So, and yes, you're right. He deserves so much better. And yeah, half Irish. Alex was cuckoo. Cuckoo. And that is up against some serious competition in this family.
That is very true.
Serious competition.
Filing stuff in Arizona, we don't know because it would be under seal. But Justin Lum, he's got you covered down in Arizona for all of that stuff. In Idaho, her attorney had 42 days to file a notice of appeal. And that's exactly what he did. Jim Archibald did. We reported on that last month. Well, then the case, she's assigned an appellate attorney, a different attorney from the legal team that has had her. And that attorney, his name is Craig Durham. He's based in Boise. He then filed an amended appeal just this week, the 4th. What's today? The 5th. So yesterday. He filed an amended appeal
so we're watching
to the
something.
original
About a
appeal
week
that was
old.
filed.
We're watching it
Some changes,
in lead up to
nothing
the
like
status
earth-shattering,
conference
huge.
that we're about to watch.
But basically, he is asking the Idaho Supreme Court to take a really close look at the case of Lori Vallow's case from basically start to finish. And in this filing, it's right here, I think it's 7 pages.
He's got the documents.
He's saying that the notice was given to the Fremont County Attorney, Lindsay Blake, to Rob Wood in Madison County, to the clerks. And he's saying that Idaho Supreme Court, I want you to look into this stuff. And I want you to see if the court erred, if Judge Boyce erred in allowing Lori Vallow to, if she was really competent. She spent 10 months in the mental hospital. Was she really competent to come?
What we're talking about is Lori is appealing based on her competency for trial at the time. She went to trial earlier this year, and she potentially, I don't know whether she's going to go for a not guilty by reason of insanity or what the deal is, or I don't think so. I think she's going for a retrial. Yeah, right.
Yeah.
Good luck. I don't think so. But yeah. So, and of course, all the wine mums everywhere are going, no, she was so competent. She was competent. Look, if I've ever seen a woman who is as batshit crazy as possible, like, that's that woman. She's nuts. Like, that woman's nuts. Considering she is still she's sitting in jail right now, prison right now, still thinking that she did the right thing, that she unalived her children and all the people that just happened to fall off their perch throughout her life. It was all for the best. And she's going to be with her savior, or she is the savior, or something like that. Really, I mean, the whole isn't the measure of insanity that you don't actually know the difference between right and wrong.
Yeah, you don't know the actions you're doing are wrong.
So I mean,
it sounds like she knew it's illegal to do that. I
am pre-forensic psychology.
Yeah.
But like, I mean, everyone likes to be the armchair speculative expert. However, I mean, really, half Irish. She's straight up evil. There's no question about that. But I mean, to me, it just seems like if anyone has a case for not guilty by reason of insanity, and I don't like that term, not guilty by reason of insanity. She's insane. I think she's insane. I think she actually does qualify for insane. I mean, like, okay, I can't diagnose her. I am not someone who can diagnose her. However, you would think her defense counsel would have at least put that forth.
Yeah.
I don't know.
Yeah.
And I do think it should be guilty but insane, not guilty by reason. But that's a whole different topic.
Yeah.
Okay, let's just keep going with this for a little bit, and then we'll move on to chat.
Back and go to trial. Look at it, Supreme Court. And did Boyce err when he denied the defense expert's request to send the defendant back, to send Lori back to the mental health hospital? He's asking Judge Boyce to find out if her constitutional rights were violated when she wanted a speedy trial, but the prosecution asked for continuances. He wants the Supreme Court to find out if her rights were violated by the court's trial setting, by having it in Boise.
Thank you, Matt.
Were her constitutional right? Were there errors with the jurors? Were there errors in opening statements? Was there errors? Remember how there was the whole issue with 404B, basically when the
interesting.
prosecution brought in the Arizona cases into the Idaho case, the defense objected repeatedly, saying, we don't believe that the Arizona cases should be brought here. She's not being charged here for those cases. Leave out that evidence. Boyce allowed it in, did tell the jury about it, and did get the defense objections on the record. So part of the appeal is, was that the right thing to do? Was that, there's, I think, 16 different things, and we'll post this so you can see it. 16 different things that her new attorney is asking the Supreme Court.
Yeah, she got a new attorney. Sorry, missed that bit.
Also, he is asking for all records that have been sealed, including Lori Vallow Daybell's mental health reports and the pre-sentence report, the pre-sentence investigation called the PSI. We will never get that. That is sealed forever. But before any felony, before any sentencing, a judge will normally order a PSI. And there's an investigator who will go in and interview the defendant and will gather up as much information as they can and prepare sometimes a lengthy document to give to the judge that the judge will consider when he gives down a sentence. Well, we learned at Lori Vallow's sentencing that she did not cooperate with the PSI investigator. She didn't talk to them. So the investigator didn't have much to work with as far as her case is concerned. So the new attorney obviously wants that. He wants to review it. And then he wants every single court reporter transcript that was compiled from her initial appearance, Lori's initial appearance on May 26th of 2021, all the way through sentencing July 31st of 2023. I believe I counted, I think there was 35 hearings.
Hello, Gameslay. How are you?
Transcriptions on, along with,
hope you're having a good day.
Anything else. Now, all of this is pretty standard. I'm sure some of you are saying, why in the world are they appealing this? It's standard. I mean, you would, if you weren't a good attorney, you wouldn't appeal. The only some conditions I've seen in other court hearings is if there's a plea agreement between the prosecutor and the defense, and then some plea agreements, they might.
All right. Oh, what he's also said is that the Supreme Court stuff is going to be televised, which is going to be great, but that won't be until a bit later now.
A decade or more of appeals, 2 decades of appeals, potentially.
Okay.
So that's kind of where things stand now for her.
No, moving on.
Lori Vallow is adjusting to prison life.
Yeah.
She, as I said, she's in the Pocatello Women's Facility.
Oh, sure, she's great.
Really don't go visit her anymore. Jim Archibald and John Thomas are off the case now.
Yeah, she sacked them.
And her other attorneys in Boise. So I don't know if they have had face-to-face visits, but I do know that, she's been now there at that prison for over 2 months. And so that's her new home, I guess you could say. And her husband, Chad Daybell, he's going to be in court on Tuesday.
Yeah, and we're going to watch
this. This is a status conference. It's basically the judge, from what I can assume, he wants to know the state of the case. Where are we at? Are there any issues? Are we still good to go for trial in April? And I imagine what he did in Lori Vallow's case, Judge Boyce, is he set aside like the first or second Thursday of every month leading up to trial for a hearing. And it was a status conference in the morning, and they would discuss any issues that needed to be discussed. So they plan it all out. I would think he would do the same thing with Chad's case. So we'll have that on Tuesday afternoon. It starts at 2:00. And what will happen is that at 2:00, Judge Boyce will hear from John Pryor, Chad's attorney. He'll hear from Rob Wood, Lindsay Blake, Rachel Smith. They'll talk about where they stand in that particular case. And then there'll probably be another hearing scheduled for November, December, January, February, March. And then we do it all over again. Jury selection again in Ada County. Jury selection, and they'll do surveys again, I imagine. And we'll be back in court on April 1st, assuming all goes as is set now.
Okay.
That trial will be far more, I don't want to say the stakes will be higher because they were pretty high in Lori Vallow's case, but it's a death penalty case. So jury selection should be longer because you'll have to really question the jurors on their views on the death penalty. And then if Chad Daybell is found guilty, there'll be the mitigation stage of the case. So then after, if he is found guilty, then both sides will then present why he should get the death penalty, why he shouldn't. There'll be experts called, most likely on both sides. And then the jury will decide whether he gets death or life in prison. So it won't be like Lori Vallow's case where she was found guilty and then 6 or 7 or 8 weeks later, we were camped out in front of the courthouse overnight waiting for her to be sentenced. What will happen is if he's found guilty, there'll then be a week or 2 of more testimony, and then the jury will say, yes, sentenced to life in prison, no, or yes, sentenced to death penalty. And honestly, I've never covered one of those. I would imagine the victims would then get a chance to give a victim impact statement, but I'm not really sure. I'm going to have to check into that to see how that all works, where the victim impact statement plays in, because I know there are victims closely associated to Tammy Daybell's family and Chad Daybell's family that want to give a victim impact statement when he is sentenced. So I'm not sure how that works, but I will find out. So that's where it stands. Now, many of you have been messaging me saying, could Chad Daybell still take a plea agreement? Yes. Absolutely. If the prosecutors ask or offer one, maybe it's instead of death penalty, you get life and we drop 1 or 2 of the charges, however it might be. He pleads guilty and then we don't have a trial and then he's sentenced. And that could potentially be done by the end of the year, I would imagine. But as of now, there's no plea agreement that he has accepted. There has been mediation efforts. We know that with Lori Vallow's trial and Chad before her trial, we know that they had mediation efforts. And mediation is basically a judge who's not associated to the case. Often a retired judge will come in. You'll put, for instance, Chad Daybell and his attorney in one room, the prosecutors in another room. And the judge basically goes kind of back and forth and says, well, what do you want? What would you accept? What wouldn't you? Okay, they want this. What do you want? And you go back and forth. Obviously, it didn't get anywhere with Lori Vallow. It went to trial. Jim Archibald said during the mediation efforts, there was no progress.
Okay, so enough of that. Let's have a little bit of a look at what people are saying, shall we? Waiting for Chad's trial. It's very important he be held accountable. Also, Charles Bellow's murder must be avenged, so hopefully Laurie's in Arizona custody soon. Hang on.
Karen's a ring.
What's that?
No, just a name.
Her name's Karen.
Yeah.
Oh, hang on. I'll just go back out a little bit. I need to be able to. So you usually do this.
She was competent the entire time. It's called narcissistic manipulation. She's been competent all along.
What's wrong with your microphone, dude? What's wrong with your microphone?
Nothing.
Bring it closer to you. Yeah.
She was competent the entire time. It's called narcissistic manipulation.
Oh, nice. Okay, here we have someone who knows how to. It must be Dr. G, but a female. Right.
Manipulation.
Manipulation. Hang on.
What?
She's a female.
It shouldn't be woman manipulation.
Oh, maybe she's saying that Chad manipulated her.
Yeah, it's always the name.
Right. Here we go. Yeah, keep going.
She has been competent all along. It's called psychopathy. Thoughts and prayers. All those animals in this cult need to be prosecuted. Justice for all the victims of these psychos.
Here we go.
Where did you get your...
Oh, here we go.
Oh, okay. One person's actually smart. Calm down. Oh, calm down, crazy lady. Excuse me? So what would you say drove her to do these things she did to her own flesh and blood? Are you part of that insane group? I sense you are somehow low-key defending Lori, or do you mind presenting us with your degree in psychology?
Hang on, read more.
Or psychiatry.
And or. Well, here we go.
Lori was competent enough to go to Hawaii with Chad after her kids were murdered. When did her competency change? When she was arrested? That's correct. She was living her life until she was charged. Anyways.
Hang on. Still wondering what exactly the difference between delusion and incompetence are. Does incompetence only apply concerning court procedures? Her beliefs are without question delusional. Exactly. She could hustle her way through 4 murders and 1 attempted murder. Just because she believed Chad's teachings does not mean she gets out of jail free card. Oh dear. Oh man. Look, here's the thing. There's a difference between competence and like batshit crazy.
Yeah.
Isn't there? Like
Absolutely.
competence a pretty low bar, I think.
Yeah.
Isn't it? Like competent to stand trial
No,
is a pretty low bar.
no, that's a little different. That's you have to know like what's going on and be able to actively assist in your own defense.
Yeah, you need to be able to communicate with your attorney.
And understand what they're saying.
Yeah, that kind of thing. Nate, thanks for the update. What's up? Oh, hang on. Laurie will never get out of prison. Please keep us informed on Charles Bellow's case. I want to see that poor guy get justice. I want to see every detail. Chad should just plead guilty. It's crazy. I love that. If he doesn't, these narcissists, oh God, people who say narcissists all the time. These narcissists need to stop forcing trials just to make foolish mental case statement at closing to the public as nobody wants to hear. The sad part is we're not going to hear the truth from him, so we'll never know why the children were killed, nor who actually did it. Actually, I think we have heard why.
Yeah.
Hey, C-Sweep. C-Sweep. Batshit crazy. Actually, batshit crazy is a really common term here. Like everyone says batshit crazy because we get a lot of batshit. Like bats just like shit on everything and ruin the paintwork on our cars. Yeah.
Huh.
Yeah.
I didn't realize you had so many bats.
We do. Yeah, we have lots of bats. Yeah, look, I feel like we have heard why the children were murdered. It's a horrific story, but we've heard it. Like they thought that they were setting them free from these demons, I suppose. So anyway, moving on.
Yeah.
Moving on. Let's get to this thing. And we have, let's share this tab instead. There is Mr. in the middle there. We have Mr. Chad himself. Now on the left, we have Judge Boyce. Judge Boyce is the man who would not allow cameras in the courtroom last time. On the right, we have John Pryor. Now, I have heard on the grapevine that John Pryor is a pretty good defense attorney, and he is far more of a aggressive defense attorney than Laurie Vallows was. Hence her kicking them to the curb since her her guilty verdict.
Is Lindsay Blake one of the prosecutors?
Lindsay Blake, yes. Yeah. Why?
She's a cutie.
Okay. And Rob Wood. Now, these two prosecutors, my goodness, they have the sleepiest voices ever. In fact, if I just wanted to go to sleep, I could just turn their voices on, even on double speed. And, right, Lordy, seriously. Okay. Who was batshit crazy? Who are we talking about now?
I
They're
don't,
pretty sure Alex killed them. Alex killed them. Which Alex are we talking about now?
we're not.
But I think Chad went along with it because he wanted Laurie to himself. Yeah, look, who knows? It's going to be really interesting to see what defense they come up with here. I mean, they could just throw it all back on Laurie and he was just in love with her. I don't know. Okay, let's get into this.
In the length, we're looking at, based on the experience we had in the companion case, timing to get questionnaires done and completed and reviewed as we conduct that portion of the trial for voir dire before
Or
evidence.
Dyer.
We're scheduled to
voir dire.
start evidence
It's pronounced both ways,
April 1st,
Yeah.
and
depending where in the country.
the court would consider that we probably want at least the full week before, like we had in the first case, if not some additional days. So I'd like to get some input on when the parties think we should potentially commence the passing out of questionnaires to potential jurors, who will then submit those.
Alex
and
did
then
it.
we'll, of course, take those back for review before we start the actual voir dire. Looking at the calendar, I was considering either 2 weeks or a week and a half. We did it in a week before, and I think this questionnaire, where it's a capital case, may take longer to both review and to fill out. So we may need to have some smaller groups. So I'm looking at maybe starting that process the week of the 18th of March, possibly on the 18th or the 20th. I don't know that we would have really enough time if we took just 1 week starting on the 25th. So that's kind of the first topic I want to discuss, and I just want to get council's input on that. Ms. Blake, starting with the state, what do you think about the necessary time we'll need to go through questionnaires, get those submitted and review them before we can start our group voir dire?
Your Honor, I think the state is in agreement with what's been represented by the court. We would be inclined to recommend that we set a 2-week time period for that. Just essentially better safe than sorry if we get through them a little bit quicker. Otherwise, I think that it may delay the start of trial if we didn't have them selected. So I guess whether we want to be a little flexible on the actual day that we start the trial, or whether we want to come in a little earlier before the set start date, would be in the court's discretion, obviously. But I think if we do 2 weeks, that would be sufficient to make sure we had plenty of time.
Okay, well, I appreciate your comments, and of course, part of that decision affects when we get things set up and are going to be there, and need to coordinate that with Ada County. And I've confirmed that they are available in those timeframes to begin if that's when we choose to start. Mr. Pryor, on behalf of the defense, what are your thoughts on starting with the distribution of questionnaires to a jury pool?
Judge, I agree with the court's analysis, and that 2 weeks is appropriate.
Okay. I will confirm those dates and get back to council. We'll still have a starting proposed date for evidence of April 1st, but we'll look at questionnaire process likely on the 18th of March. So we may submit a supplemental order that covers that. If not, I'll just make sure that council's advised of the dates we'll be doing that. So that's the first issue I wanted to discuss. In terms of our length of trial, assuming we do start evidence on or about the 1st of April, we've got it set through the months of April and May as it currently sits. I just wanted to get an update from the state as to whether or not you think that is still an accurate time frame for your trial, Ms. Blake.
Your Honor, I think the 8 weeks would be sufficient for the state's anticipation of the length of this trial. I think, again, given some of the differences with this one versus the companion case, including that it is still a death penalty case, I think having that longer period of time for the trial is appropriate and would give us enough coverage if we set it for the 8 weeks, not including the jury selection.
Okay. Mr. Pryor, any thoughts on our current scheduled time frame and whether you think that's adequate?
Judge, I agree. The 8 weeks is, at a minimum, is probably the appropriate amount of time.
8 weeks.
I think Ms. Blake and
Damn.
Mr. Wood are well aware that, at least in this case, the defense is going to put on a defense. And I have a number of expert witnesses, which is another subject we need to discuss. So at least,
An NPC is a non-playable character, right?
Yeah.
Yeah. Yeah, see, you just learned something, right? And oh
at
dear.
least 8 weeks would be.
We're so
Very well.
mature.
We'll keep the trial schedule as it sits for now then. The next matter I wanted to raise involves the access of cameras in the courtroom in this trial.
Here we go. It's
In
the
this
big one.
case, I'll note that on September 23rd of last year, an order was entered revoking authorization for live streaming the case that was issued in this case and came about as a result of motions made in the companion case. There was a motion filed by the defense, Mr. Pryor filed on September 29th of last year, requesting that we do allow cameras in the courtroom. And the court issued a follow-up order on October 12th of last year and discussed that if these, at the time the cases were joined and they were later severed, of course, in this order, the court mentions that if the court did order a severance of the cases, I would permit the issue to be revisited and would consider that these separate cases may have separate rationale for allowing or disallowing cameras in the courtroom during trial. So without arguing the motion today, because this potentially raises the right of media intervention into the issue, I would just like to schedule a hearing, and the issue would be the determination of cameras in the courtroom for trial. At last posture, the state opposed it and the defense was in favor of it. Has that status changed on behalf of the state, or do you want to wait until the hearing to more fully discuss that, Ms. Blake?
I think I can indicate at this juncture, the state will be maintaining the same position. We can, of course, address it more thoroughly at a hearing on this matter if we end up having one.
Hey, Ken.
Okay. Mr. Pryor, any thoughts on cameras in the courtroom on that issue and scheduling hearing on that?
Judge, I think it's important that the court set a hearing date on that. Without
going on?
disclosing a lot of information, I have not returned or responded to the numerous requests from media to pursue a motion like that. And it's quite frankly not my job to represent any of the media people out there that are inundating my email and everything else with requests. But I think at this point, given the fact that this case is going to trial, and I expect the media to probably now jump all over the court's inquiry, we
What
probably
errors
better
there?
have a hearing and have the matter addressed.
100%.
Mr. Daybell has not changed his position since I filed this motion. Still maintains his feeling about having a public trial, but Judge, I think at the time of the hearing, we'll make a final determination.
Okay, well, let's schedule a hearing then, and I'll want to set enough time that if the parties wish to file any motions in support of or against, what we'll do is it's a hearing to determine whether or not my September 23rd, 2022 order should be amended or altered or left in place. And I'll consider argument on that. So I would think,
Okay, I'm gonna stop it right here. Well, outline Yeah, that's one way of looking at it. I suppose.
Yeah.
I mean, the other thing is that, like, it's possible that he or his attorney, who by all accounts is very well respected, like he's a good attorney, is of the mindset that this should be scrutinized from all angles. And it's a death penalty case. Like, this is his life's on the line. We don't want there to be any shenanigans pulled whatsoever. So everything should be out on the table. And yeah, of course, there's, I mean, in these situations, there'll always be the defendant's last opportunity to have some limelight, I guess. But what did you say, old line? Don't get me wrong, I believe in public trials, but he was a bit of a fame grabber from the start. Yeah, sure. And I don't deny that at all. But I feel like in this instance, what's the one party here that doesn't want there to be cameras? And it's the state. So what's with that? What's with that, people? What's going on? What's the
Very
problem?
suspicious.
That's sus. Why? Yeah. Why? Because I thought it was the judge.
Yeah.
I really thought it was the judge. I thought the judge was the issue here. I thought he was the Judge Boyce back in Laurie's trial. I thought he was the one putting his foot down and going, no, I've had enough. I don't want there to be a media circus around this. I don't want there to be, I don't want the jurors to be potentially distracted. I don't want there to be some sort of, it's already going to be a 8-week giant, it's going to be a giant undertaking as it is, to have cameras coming in and out, and the media just, like, they're already going to be on our doorstep, to have them coming in as well, and then to have the whole world talking about what's going on in the courtroom visually. Sure, okay, fine, he relented and allowed there to be audio, but I think he was being very conservative, but he seemed to be the one that was against the cameras. But now he's singing a different tune, and it's like they've had a practice run. They've done this, right? So now they've done this, pretty much done this trial. Like, they've done it before. And I feel like Judge Boyce is more comfier with the situation. And now he's like, okay, cool. I see no reason why we shouldn't be doing this now. And he's really wavering, like he's really considering it.
Yeah.
I feel like he'd go ahead if it weren't for the fact that the prosecution's saying no. Yeah. So what's the problem? What's going on? I don't get it. Yeah, I don't get it. What'd you say, online? I believe if he wants cameras, he should get them. I don't think he's a noble motives kind of guy. Well, yeah, I don't think. Well, yeah, I don't. Yeah, you're probably right. Like, I doubt that Chad is like, oh, I want there to be justice. Yeah, you're probably right. You're probably right. He should get them though. Like, why not? Why not get them? That's what I'm more interested in here. Like, why not get them? What's the state's problem? I want to know what the state's problem is. I'm very curious.
Council, would it be reasonable to look at a December setting for that motion?
Judge, I think that's probably a good idea.
Here's Mike's crackling.
Quite frankly, based on the amount of attention I
Absolutely.
seem to draw on this issue. I can't speak for what the state's getting requests for, but I expect, unfortunately, that a number of media outlets and other folks are going to jump all over this thing, and I think it's going to take some time to properly address it.
All right, I'm just reviewing my calendar. I'm really pretty booked up in December, but I can move some things around.
I don't
Um,
know, old line. I'll have to look into that.
I have a little concern, sorry to sit here and get through my calendar. I've got a couple of trials that I think might be happening with Fremont County on the week of the 11th. What about Thursday, December 7th?
Judge, I have a matter on that day that I have to attend to. I apologize, but other than the week of the 4th through the 8th and the 20th, I'm available at any time.
Dali, you've got a fan.
Thank you.
Judge, may I interject?
Yes.
Whether the court decides to have cameras or not, it's not going to change the tempo of how I prepare. I can't speak for the state. So if the issue was even addressed in January, quite frankly, it would just be the media would have to scramble, and that doesn't necessarily hurt my feelings. So if the court wants to push it to January to make a decision, I
Doesn't
have no problem.
hurt
I
his
can't speak for
feelings.
this, whether that's acceptable to the state or not. But I'm comfortable going into January on this issue if we need to.
All right, the alternative I'm looking at is maybe move that up a little bit to November 29th.
He just was like, nah, I want to get this done.
I'm available on the 29th, Judge.
I would likely be holding this as an in-person hearing as well, Mr. Pryor, just so you know.
Okay, thank you, Your Honor.
Ms. Blake, would that date work for the state?
That date will work fine for the state, Your Honor.
Okay, let's set that then for Wednesday, November 29th. We'll set that at 9:30 a.m. in the Fremont County Courthouse.
Taking
And
notes.
that will be a hearing to determine media access to the trial as it relates to the court's September 23rd, 2022 order. If the parties wish to file any motions in support of or opposed to any modification of the order, I'd ask that you submit those by Wednesday, the 22nd, which would be the day before Thanksgiving. All right, we'll get an order out setting that. Anything else to address on that issue, Ms. Blake or Mr. Pryor?
Nothing further from the state, Your Honor. Thank you.
Nothing from the defense, Your Honor. Thank you.
All right, counsel, that I think covers what I wanted to specifically
Is Chad
address
checking
today.
his calendar?
Are there any other matters while we're here on the status conference that either party wishes to raise as we get towards the road of preparing for trial? Ms. Blake, is there anything the state wanted to address for the status conference today?
Yes, Your Honor. One of the reasons that the state had wanted to have a status conference is with the last case, and especially when the cases were joined for trial, the court had set a monthly hearing date that we just had a day set aside so that we weren't scrambling to find dates to coordinate with counsel's calendars in the courts. So we would like to request that the court consider doing that. The state does have 3 motions that we intend to be filing here in the next week or so. And I'm not sure when the first availability for a hearing date would be, but if we could maybe set a monthly date just to have that preserved. So that was one issue. Another one, and I think Mr. Pryor was going to address this as well, but we just wanted to make sure that we had the discovery deadlines, that we were all on the same page. I think there was some confusion or concern on the expert deadlines. We had modified those previously when it was a joint trial. We changed those up a little bit. So I think we just wanted to make sure we were on the same page with those disclosure deadlines. And with the court setting the jury selection, I think we also just wanted to double check if jury instructions, if that's going to affect any of those filing deadlines. Since the official trial start date would be April 1st, but we would be starting some other stuff on the 18th of March. We just want to make sure that doesn't impact the deadlines. And then we also, I think the court was waiting on a stipulation from the parties regarding some DNA testing that had been requested by counsel. In fact, that was the main basis for the severance in this case. It's our understanding that the defense is not going to pursue additional testing. We wanted to make the court aware that the state is not going to pursue additional testing at this time. That has been a little frustrating for the state because we do feel that that was, if not the sole basis, the main basis for the severance. And we're now incurring a second cost of trial, time for court staff and of course the offices involved in this, as well as extra testimony for the witnesses. So it is a little frustrating, but we did want to update the court that it's our understanding that testing is not going to be completed, so that the court is not waiting to see that or a stipulation regarding that matter.
Okay, well, I was not aware of that, so I appreciate you bringing that to my attention.
The echoing, Judge.
In terms of the,
Thanks, Boomer.
thank you, Ms. Blake. And I'll get to you in a second, Mr. Pryor. I agree it would be helpful to begin with at least monthly set dates for motions. In lieu of trying to dig through calendars today, I'll reach out
It's good to be regular.
likely through my staff attorney or through an email to counsel to get availability. For now, I will intend to hold at least once a month pretrial hearing dates on a standing basis so that the parties have time to argue any motions. We'll start with this November 29th day, and where we've got the media issue scheduled. If the state wants to tag on any other additional hearings on that day, let's do that. If you think you need something before then, contact me, and then we'll go ahead and look at a date for December, January, and February, and make sure that council's all available on proposed dates, and we'll get monthly hearing dates set on the calendar going forward. In terms of the discovery deadlines, it sounds like Mr. Pryor wants to address that, and the court's scheduling order. What I will say is I will go back and take a second hard look at our scheduling order and determine if it looks like we need to modify that to accommodate the beginning of questionnaires, for example, and look at other deadlines and make sure that everyone will have adequate time for disclosure. So I'll take another look at the scheduling order and take that issue under advisement for now. Mr. Pryor, is there anything you'd like to address today at the status conference?
Judge, just a firm date on the disclosure of expert witnesses. I will take a little bit of issue with what Ms. Blake said was the reason for the continuance. My recollection is getting discovery just on the eve of trial in terms of DNA evidence was the reason.
Gamesley. Yep. Okay. So this is just a conference, a status conference. Everything's on the record, but these guys aren't testifying right now. So what happens is when they go to actual court, and they put witnesses on the stand, that's when they go under oath. So
Or if they testify over Zoom, then
yeah, or if they testify. But these guys are all officers of the court, so they are lawyers,
they already got
and everything.
obligation
So they have an obligation to tell the truth anyway. So that's part of their profession. Hope that answers your question. And I hope I'm right.
Yeah.
Because I'm only pre-law.
No, I
But
know.
yeah,
Oh, yeah, you're right.
I think I'm right. And Dali's also put a explanation here.
Reason for that, but we're not going to argue about that today. I had to go through a significant amount of time with an expert to make a decision regarding the DNA evidence. So it wasn't as simple as just saying, well, I don't need any more information. So I do need a firm date to provide for my experts and the additional experts that I now have retained. And I'd like a drop-dead deadline on disclosure of all witnesses and a discovery deadline as well, so that I can make sure that I have everything to the state, so that we don't run into the same kind of problem that we did with the state not getting all the discovery to us on time. So at this point, those are the three things that I would request, Judge. Thank you.
All right, well, with that in mind, for now, the scheduling order will remain in effect. If it appears
Hello.
we need some additional clarification, or given these alterations potentially in the trial start, we need to modify any of the current deadlines. The court will issue a amended scheduling order. If I believe we're changing things significant enough that I should get your input on, then I will allow hearing on that and argument before I just unilaterally impose new deadlines on you. So we'll go back through our scheduling order and see if it looks like it'll suffice for a trial of this magnitude. And in terms of the issue on the further DNA testing, I appreciate counsel advising the court of that. Clearly, with the representation made here today on the record, the only substantive change that has in the case is that would likely then not be considered any cause or good cause for any request for a trial continuance if suddenly somebody decides they do want to have it tested and there's not time before the trial. So I'll take you at your word that it's not going to be tested, and so it wouldn't create a basis for any delay in the case. And we will look through the scheduling deadlines to see if anything else needs to be modified. I'll also make sure we reach out to counsel to get our standing hearing dates scheduled starting with December. And if you think you need a hearing before November 29th, then contact the court.
And Judge, I looked at the court scheduling order, and I'm just a little unclear as to the actual deadlines and what I represented in terms of disclosure of witnesses and that. So if the court could reach out to all parties just to make sure that we all know what our deadlines are.
It disappeared.
I'm confused on the scheduling order, but that can be done in another capacity and a different type of hearing if necessary.
Okay, fair enough. We'll look through the order and add any clarification that appears necessary.
Thank you, Mark.
All right, that'll conclude the issues I had today. Ms. Blake, is there anything further the state wish to bring to the court's attention this afternoon?
Your Honor, just one additional thing, and I know the court's directed us to reach out to the clerk, and I'm happy to do that. I did just want to give everyone a heads up on a couple of the state's motions. We are going to be reaching out to see if we can get an earlier hearing date on those. And then that brought to mind, I think last time, I don't remember if it was a formal order of this court, but I think we'd set some deadlines on filings. So if one party filed a motion, I believe it had to be 14 days before they scheduled hearing. And that would give the other party time to file theirs 7 days before. And then so I just wanted to check if we are going to stick with something similar, just so we know as far as when we're trying to set a trial date that we stay, or not a trial date, excuse me, but a hearing date that we stay within those parameters.
All right. What we can do is incorporate some language that would cover response and reply deadlines in our notices of hearing. So I think it's a good point, Ms. Blake, to make sure that we're not getting hit with voluminous filings just on the eve of hearings, so that everybody is prepared. I'll include language in future schedule of hearings to incorporate deadlines for filing of motions to be heard on those dates, as well as responses and replies. Mr. Pryor, anything else to bring up this afternoon?
Judge, just that I'm a bit concerned Ms. Blake's going to try to get a hearing date before the November 29th hearing. And I would note, Judge, that I'm a little stacked up, and given the holiday or Thanksgiving coming up, I'm not going to be difficult, but it's going to be difficult for me to find some time before the 29th of November to have such a hearing. Knowing that we discussed with Ms. Blake what those hearings are, I'm going to find that problematic. So just so the court's aware of it.
Too bad. It's
All right,
just that,
well, I'll leave it up to council to contact us and schedule things and try to work together to have a agreed upon date. But if it can't, then I'll set hearings for you. So I appreciate the concern there, Mr. Pryor. All right, I believe
you're
that'll
unbranded.
conclude this portion of the hearing today. As I mentioned before we started, there's also an ex parte issue that the court finds is properly brought by the defense. I will conclude this public part of the hearing, and an ex parte motion will next be heard, which will be sealed in a closed hearing, and the court will allow Mr. Pryor and Mr. Daybell to remain in this hearing and ask that all other parties be excused. So
Shifty off.
thanks for your attendance this afternoon. Let's go ahead and take about a 5-minute recess to clear everyone out of the courtroom, so to speak, virtually, and then we will continue with the ex parte hearing, Mr. Pryor.
What's ex parte mean? Is it just being out of here? Lawyers in chat, help us out.
The hearing conducted without the opposing party present in court.
Right, ex parte, that makes sense.
Okay.
Right. Yeah, a video unavailable is at the end of it. That's very professional of LMC, just to chuck video unavailable there. That makes sense. Good for them. And just go like that. And let's have a look. What have people got to say about that? Anything exciting? It's time for him, Laurie, or both to tell the truth. Hang on, can you see that?
Yeah.
Go, Dali. Do your thing.
It's time for him, Lori, or both to tell the truth. If either of them have ever had an ounce of love for their victims or an ounce of faith, they know that the only way for either of their hearts and souls to be free is to tell the truth. Their bodies will be imprisoned physically, emotionally, and spiritually until they can admit to the horrific thing they've done to those who trusted and loved them. They know they've allowed this insanity of zombies, past lives, spiritual warriors, and dark spirits to spiral into an elaborate dark fairy tale to justify their actions. The actions that they committed due to greed, lust, fantasy, and pure selfishness.
Oh,
I
wow.
believe they will remain in prison until their last breath, as they deserve. But if they have an ounce of dignity, an ounce of love, and compassion left, then do the right thing and tell the truth and own what you've done to those who loved and trusted you.
Oh, God. Okay. That was flowery. Oh, dear. Okay. Oh, here we go. The defense is going to put on a defense. Wow. Such words of wisdom, Mr. Pryor. Thank you for enlightening us. Ah, dear.
They don't have
Okay.
to put on a defense.
Oh, yeah. Well, okay. And what's this? Ooh, can't wait to hear John Pryor say, quite frankly, 5,000 times during the hearings and trial. Not. It'll be interesting to hear his defense of Daybell.
Oh, yeah.
Look, when will people understand that everyone deserves a defense?
Yeah.
When will people get it through their heads? It never ceases to amaze me. Here we go. Oh, yeah, see, he's going to become public enemy number one now. Just like,
Yeah.
can't stand when people say poot.
I know.
It's just like, give him some respect. He has done nothing
Yeah.
wrong. Okay. Pryor whined and whined about the DNA, and now he doesn't even want to acknowledge the temper tantrum, which severed the case, which I believe was his intention the entire time, because he's a slime ball and cost the families more trauma, the state more money, and gave him another year to plan his defense. It was dishonest and should be, what? I don't know. Look, it gave him another
Yes.
year to plan his defense. He needed another year to plan his
Yeah.
defense. It's got the death penalty on the table. Man,
That's funny. Old line read. When I was like 16, my criminology class, the teacher had a friend who was a lawyer, criminal defense lawyer, and he comes in to talk to the class. And one of the kids in the class is like, "Well, how can you live with yourself for doing this?" So he just laughed and was like, "Oh, you're thinking about this evil person, right, that committed all these crimes. Now, in this scenario, did you ever consider it was your brother or your father
yeah,
or somebody you love? Would you not want them to get the best defense?"
yeah, exactly. It's not just that it's presumed innocent in the eyes of the law until proven guilty. Oh, like that is just non-existent. Like that idea is just, it seems to have gone out the window. Yeah, the defense will give us a defense. That's so true. Like they're supposed to give us a defense. They're supposed to. That's the whole idea. Yeah, it's so right. By JJ's grandfather hugged and thanked Laurie's attorneys because he understood she needed a defense. Now that's interesting. That's
Who's
very
JJ?
interesting. JJ's the little boy,
Oh,
the murdered little boy. Yeah. And JJ's grandfather was actually like the guardian. Like they helped bring him up.
Oh, really?
Yeah.
That's very interesting.
Yeah.
Good
We
for
can
him.
pre-hate them, but they still
Get a just
get a
trial.
just trial. So they should. Chub Daybell pulls off the very difficult task of having a weak but triple chin. Very rare. That is true. I mean, I gotta give it to that person with that comment. He does have both a weak chin and a triple chin. That is actually true. Yeah, that's actually quite funny. The
It's
judge
like, it's
mispronouncing
pronounced.
Wadia. Okay, well, I mean, I did think he pronounced it wrong, but he's a judge. He knows better than
Yeah.
me. So I'm pretty sure he knows how to pronounce Wadia. Oh, here's someone else correcting him. With all due respect, Your Honor, it's pronounced voir as in reservoir and deer as in deer, like as in.
It really
Like a
just
deer.
depends on like the state and the part of the country.
I mean, I think the guy's guilty of sin, but who am I? I have an opinion based on feels, not facts. Yeah, look, okay. We haven't heard his defense yet.
Yeah.
We haven't heard his defense yet. And look, there's a mountain of evidence against him, clearly, that we've already heard it. We've heard a bunch of evidence against him. We haven't heard his defense yet. And I don't think he's getting off by any stretch of the imagination. There is just no way that he's going to just walk free. Like, that is very, very unlikely, I don't think.
Yeah.
But I think that he still does deserve a fair trial, like everyone deserves a fair trial. Now, the plan is, from here on in, that as Judgy Judge said, there's going to be hearings. Or hearings are status conferences once a month. And the next one is going to be the exciting one about whether or not we are going to get the cameras in the courtrooms.
Yes.
And everyone's going to be waiting to find out whether that's going to happen So we will definitely be on that one. In fact, the plan is that we're going to be streaming every one of these status conferences up until the trial, and any other developments that happen, not just on the Chad case, but also on his not lovely wife, who is looking to be potentially extradited to Arizona by the end of this year. So she very well may be in your county, Mr. Dali, by 2024. You could go visit her, say hi, yeah, or not. And yes, you could be an MLSN reporter on the ground for the pre-trial motions and for the trial itself.
For sure.
For sure. You might have to get that suit fund happening again.
Yeah. That would be
Think you will. And we can actually get those little mics with the MLSN on it.
good idea.
Imagine.
That'd be awesome.
That'd be awesome. Or maybe little lapel pins. And,
Yeah.
cute. How fun would that be?
Yeah,
Oh, here we go. Here's a reason even most law of the crimers should want a good defense. You don't want criminals to get appeals for dumb reasons. Yes, that too.
Yeah.
Yep, that too. All right. We're gonna probably wrap this up now. Now tomorrow, Dali and I are gonna do something different.
Yes.
And it's gonna be fun. And it's not gonna be all law and crim. It's going to be all about me finding out fun stuff about America.
Brand new subject.
Brand new stuff, right? Because you know how, like, sometimes he'll say, oh, like, and he'll just mention a random name, like a random US, like, commentator or celebrity or, like, a journalist or even a lawyer or something, and I'll be like, who's that?
Yeah.
And he'll be like, you don't know who that is? Oh my God. And everyone will be like, what? And I'll be like, no, I don't know who that is. And so we had the idea that Dali just chooses one and shows me video of them, and I'm like, what the hell?
Yeah.
Right. And everyone in chat, can also like
like a big thing that happened to someone.
Or a big thing that happened. Like, I did not know that ever happened. Yep. So teach the Aussies. I'm bronzed. Teach the Aussies. So make sure you're there, because I also like want people who are not US, especially Aussies, or even people from Europe who might not know about some crazy thing that's happened.
Yeah.
And I'm not going to tell you what the crazy thing is, because tomorrow is just a crazy thing that happened.
Okay. So that'll be a surprise.
It's a surprise. Yep. Or you'll find out later today when we put the thumbnail up. Yeah. But later today, tomorrow morning, whatever it is your time. But we're going to do like a react stream, and everyone gets to see, like, either I can't believe EU didn't know that and tell me all about it, and it's going to be hilarious and fun, or I didn't know about that, and what is that?
Yeah.
So it's just going to be a bit of fun, hilarious stream. And then on the weekend, we'll be into Pains of Our Lives again, and probably the last of the Chazzle Dazzles before I start a new rewatch. And I'm going to tell you on the weekend what that's going to be. It's going to be crazy. A new rewatch with pub quiz. Yay! Fun. Thank you, everyone, for joining us. First of our Doomsday coverage. And that's about it.
See you guys later.
Unless anyone else has anything to add. No, I just get my little thingy bob going. Thank you, everyone. Like and subscribe.